All right, now I'd like to welcome to the show Betsy Sanz, litigation fellow at the Institute for Justice. Welcome to Free the Economy, Betsy.
Thanks, Richard. So nice to be here with you.
So I understand that you're involved with an important lawsuit, a big property rights case down in Georgia that involves a railroad and a couple of families. What is that case all about?
Well, the case is a case of a railroad that wants to take land from several parcels in order to connect a long line railroad to a rock quarry. Uh, so this railroad is run by the Sandersville Railroad Company in Georgia, and the quarry is located in Sparta, Georgia, which is a rural area a couple hours south of Atlanta. Um, there's a lot of open land down there. It's a very natural place. The landowners, our clients, have uniformly owned their property for many, many years, a couple of families for many generations. And the land is very meaningful to them, and they don't want to sell. And so the railroad has proposed to use the power of eminent domain to take the property that they need and want.
So this is really a case of a single company wanting to do something as a for-profit expansion of their operations. It's not something like the way eminent domain powers are sometimes used for a road or for something that will benefit the community in general. This is just sort of one company coming in and said, well, we want to do this project, so we want to take this land, right?
That's right. So just a bigger picture here. So the quarry, the rock quarry that this rail line proposes to serve is currently producing rock. They are getting their product out of the quarry using trucks. But the quarry wants to expand, and the private railroad company, which is a short line railroad company, wants to help them do that. And when this issue came up earlier in 2000, well, it started in 2022. IJ got involved early in 2023. The railroad had promoted to the public that the whole purpose of the line was to help the Hanson Quarry produce far more rock, and that the benefit to the public would be all increased tax revenue and creation of jobs. And those were their primary messages to the community. Once IJ got involved, we pointed out that economic development is not a public use in Georgia. We can talk a little bit about that. So I think that they've backtracked a bit, and they're trying to say, well, it's not economic development that this public use. It's really more like this is a new channel of trade, but the ultimate result of it is not really a use that's going to have a very public nature. It is going to serve the rock quarry, which is owned by a multinational corporation, and since in the last several months, the railroad has added potential users, and we can talk a little bit more about those too. But ultimately, nobody, the end result is private benefit to a very small number of people, including the railroad and its wholly owned businesses. So it's a little bit of a mess, and they're trying to present that this will be, a public use, and it's clearly not.
Well, this is an interesting case because often, on the show, we talk about the need to reform land use regulations to make it easier to build things, to build big, important things like transportation infrastructure, even. But of course, in those cases, it's usually a government agency standing in the way of people who are the property owners and
Right.
developers and who already legally own the land in question and telling them they can't build what they want to build. Obviously, in this case, it's almost the opposite. It's very different, and I think it's important to remember sometimes when we approach a situation from first principles, it's going to dictate a very different outcome depending on whose rights are really at issue here. So in general, we would say, oh, more economic development, great. More transportation infrastructure, great. But not if you have to steal someone's land to do the deal.
Correct. We agree with you. So, you know, at the Institute for Justice, we are all about free enterprise, and we are about people being able to use their property as they see fit. Um, we are also about people being able to retain their property when they don't want to sell it. And if there's going to be a taking of their property against their will, it better be for a darn good reason. And so these kinds of cases that don't come up to that standard. And so that's why IJ stepped in. Um, there was a so just to give you a sense, if you want to hear about it, give you a sense of where we are in the process. So the railroad is a private entity, and under Georgia law, they are categorized as a public utility, and public utilities are delegated this state power of eminent domain in certain circumstances, and so what the railroad had to do before it could propose to take land by eminent domain, it had to go to the Georgia Public Service Commission, which is the agency in Georgia that regulates public utilities. And they have to ask for permission to obtain the state's power to exercise eminent domain in this situation. And that hearing at the Georgia Public Service Commission was in November. And the parties are currently briefing their positions post-hearing. And an initial recommendation from the hearing officer that presided over the hearing will issue in early 2024. And then the commission will either choose to adopt the recommendation of the hearing officer or not. So we're in this agency process where the state will kind of, you know, determine that this is a public use or not. And that's what has to happen for this railroad first. It just underscores the fact that this isn't even the state, right? This is a private entity, and private entities don't get to, you know, private entities don't get to take property from private individuals, right? The state has to be leveraged to do that. And so at the hearing, we were lucky enough to have the testimony of Donald Koshin, who is a professor of law. He's the executive director of the Law and Economics Center at George Mason Scalia Law, and he was there to give the hearing officer some insight into, you know, what's the reasoning for this limit on the eminent domain power, and why did the founders of both the U.S. Constitution and the Georgia Constitution have these clauses in their Constitution that say you can't just take it has to be for public use. You can't just give from one to another. And so the function of these clauses is to make, the way that Professor Koshin put it, is to make these forced transfers of property from one private or from anybody to anybody be very hard and very costly and very rare. And instead, what entities like this railroad company are trying to posit is that it should actually be easy, cheap, and common for this transfer to happen. And so we're there saying, no, the standard should be that it is hard, costly, and rare, because, you know, otherwise, why engage in a market transaction, right? Why try to negotiate with a private property owner? And why would an entity like a railroad even look anybody in the eye and say, I acknowledge the value that this land brings to you, and I'm going to engage with you in order to see if I can give you something more than that value, like all of us have to do in a market transaction, right? But instead, what happens here is that you get an entity reaching for the power of government to make it cheap for them to get the land that they need to do whatever, you know, they're proposing to do. So
yeah,
IJ is there, you know, standing up for it, saying no, they shouldn't be able to leverage the power of government for this clearly private benefit.
well, exactly, and I think so. You know, every state has, you know, slightly different laws and regulations, you know, governing these sorts of things, and so the situation that prevails in Georgia would necessarily be the case in every other state. But I think
Right.
it's an interesting detail you throw in there that the railroad is being treated as a public utility in this context, and so that's its sort of toe in the door about why it has the opportunity to push in this direction in the first place. Because of course again, the example of the idea being that this is supposed to be something like rare and only for very special, specific, extraordinary circumstances, the sort of public utilities, like whether it's electricity or it's water or something, the idea is, well, we couldn't have people living in the state without any drinking water. So maybe if like the water utility really, really needs some land for something, maybe then that would be an exception to our normal protection of property rights, and then we would go forward. Or, well, we gotta people have to have electricity to turn on the lights, so maybe there'll be an exception for that. But this seems to me, well, perhaps maybe an accident of legal history in the state that a railroad gets classified as a utility in the first place, similar to some of these more kind of like essential and necessary ones. But because of that, um, it a private for-profit company like the railroad has a sort of opportunity into the system in a way that maybe they wouldn't in some other states.
I think that's fair. And with railroads, the history is so long, and it's not uncommon to see a railroad, categorized as a public utility or something of that sort in many states. But in regard to Georgia law, the railroad is looking to exercise the power of eminent domain here. And of course, we know that in the Kelo case, the court, it was just one more instance of the court, really making the definite, the broadening the category of uses that could qualify as a public use under the United States Constitution. And in Kelo, as we all know, the court held that economic development was was a qualifying public use under the United States Constitution. And it was such a reviled decision that many states in the wake of Kelo moved to strengthen their own eminent domain laws, and Georgia was one of them, thankfully. And so in 2006, they amended their laws to explicitly state that economic development is not a qualifying public use for purposes of their public use constitutional provision, or their eminent domain constitutional provision. So we do have a situation in Georgia where, yes, you have these old, these laws that have been in place for a long time, kind of granting railroads this enormous power in certain circumstances. But we also have an even newer law that it was called the Property Owners Bill of Rights, or the Landowners Private Property Protection Act, I think it was, in Georgia, that this amendment fell under. And so Georgia, their legislature takes private property rights seriously. They certainly haven't confronted those 2006 post-Kelo amendments in the context of a railroad taking. And so this is new, and they're going to have to confront that, because you have some laws that are just in tension. But to your point about the broader uses, this is not a situation where you're bringing water to a whole region of the state, right? And it is certainly not a situation where you're bringing electricity. I think that you could make a much more reasonable case that kind of use, if you're going to take land for that kind of use, the public nature of that use is so much clearer than in a situation that you have like this, where just, like primarily like 99% of the benefit of this track is going to go to an aggregate company, which is already producing and being able to transport its goods. It just wants to do it faster and for cheaper to itself, right? And then you have a couple of other companies that once the track is built, see some advantage in it of their own for their own. But that's it, right? Like that's it. That's not a public use, right? That is not bringing water. That's not bringing electricity or anything near that level of benefit.
Yeah, and I think so. This, the case you mentioned is pretty famous among attorneys and constitutional scholars and whatnot. And we mentioned it before here on the show, but I just want to go back quickly and sort of flesh this out for people who haven't heard of it before. So the Supreme Court had a decision that came down in 2005 in a case called Kelo versus City of New London that involved some, and actually people might know about this case from the 2017 film Little Pink House, which starred Catherine Keener as the real life plaintiff Suzette Kelo from
Sure.
New London, Connecticut. So Suzette Kelo owned a house in the city of New London, Connecticut, and a company wanted to come in and wanted that land because they wanted to build a corporate office on it, and she did not want to sell. She was pressured to sell, and eventually they were able to use eminent domain to take her property. She sued, and that case went all the way up to the Supreme Court. As you said, the Supreme Court's decision in that case was not great from a property rights perspective because it made it easier for states, municipalities to grant that, to take that land and sort of hand it over to companies using only sort of economic development as the reason, not sort of like provision of essential services like like we've been talking about. But the response, which you described, that lots of, I think dozens of states across the country passed laws of their own of varying degrees of stringency, saying, well, the Supreme Court has said it doesn't violate the Constitution to do this, but we can still choose in our state not to allow it.
That's
Right.
right.
So there was a kind of, I can't think of, I can't really think of another Supreme Court case where there's been such a kind of ironic response, which you had a decision that sort of pushed the law in one direction, but then you had specific state legislatures passing so many laws in a way in sort of the opposite direction that strengthened
Immediate and
protections.
opposite reaction. Yes.
Mm,
Yes. Or equal and opposite.
mm,
Yeah. And immediate. Yeah, that's right. The response was, it was because I think that people realized, there's always uh, basically what Kelo stands for is the proposition that somebody else can come along and say that they can use my property more productively, which might result in more tax revenue. Like any Motel 6 could be outperformed by a Ritz-Carlton, and so why not give that property, take it from Motel 6 and give it to the Ritz, right? It just blows open the doors for entities who can convince a lawmaker that they can make more productive use of the land, resulting in, um, more benefits to, like, more economic benefits to the municipality. It's just very dangerous. And so I think the average person could see, maybe more than in some cases, that could really affect them, right? Like where's the limit? And indeed, the limit is unviewable. And
mhm.
so there was a lot of success across the country. IJ immediately, as soon as that decision came down, the Institute for Justice, which your listeners probably know that Kelo was an IJ case. I mean, IJ
Mm.
represented Suzette Kelo. And so, of course, it was, very near and dear to our hearts to make sure that, we could do what we could. And so IJ immediately started advocating. So if we couldn't get it done under the Constitution, let's go to the states. And so for your non-lawyers out there, what the Supreme Court said at the end of the Kelo decision was true. Under the United States Constitution offers a baseline of protection of certain rights. States can be more protective of rights if they choose to be. They just can't be less protective of rights than the federal
Right.
Constitution. So because the federal takings clause under Supreme Court precedent just doesn't have a lot of protection, states can do something more. And that's exactly what a lot of states did after Kelo. They said, no, we're going to be more protective of private property rights, and Georgia was one of them. And so we're banking on, and we're confident in that, reality.
Yeah, so you have Georgia's own law. How does it compare to some of these others that were sort of like passed around the same time? Is it especially strict, sort of medium strict?
I think it was probably medium strict. Now, I'm not personally familiar with all of the states, the status
Mhm.
of, but IJ publishes a map, and I can send you a link if I don't know if you include links in your show notes, but
Yeah, we
I
do.
can send you. Okay, let's do that because so IJ has a um, well, eminent domain is an important issue for us, and we cover it very thoroughly. And for those post Kelo amendments, we have a whole map, so you can go and see what how protective your state is, what the history of your state's activity after a Kelo. And I know that Georgia is rated B plus by the Institute for Justice, and so there are states that are not rated B plus. But of course, there are states that are rated higher, I think. So I think that Georgia could be seen as being, pretty protective comparatively. But yeah, that's a great resource. And I don't know if am I the first person from the Institute for Justice that you've had on your show?
Oh, I think you might be.
Okay. Well, people should know that, one of IJ's issue areas where we litigate is private property, and eminent domain, and eminent domain is a big issue within that category of cases. But we also have a strategic research arm that does like scholarly research, and some of that has been done on eminent domain stuff too. So there's a lot of resources at our website. So I'll send that to you.
All right, excellent. And now here there's one more angle to this I think is kind of interesting where so we've talked about the protections at the federal level versus protections at the state level, things like property rights. And I assume most of these eminent domain decisions are being made pursuant to a state law, but often they're made by municipalities,
Yes.
right? So it's a city or perhaps a county that votes whether they want to sort of do this in the first place. Um, and I wonder, so when we think about a lot of times people who are sort of, libertarians, small government people, people, the sort of conservative legal movement, we think that the best way to protect individual rights, often, or we imagine, is with the government exercising power at sort of the lowest down, most local level, devolving federal powers to the states, for example,
Yeah.
people often say that. And but it's certainly clear that local governments can go off the rails, so to speak, just as much as policymakers, higher up the food chain. And I remembered of this book all the way back in 1993. The Cato Institute published a book by Clint Bullock titled "Grassroots Tyranny: The Limits of Federalism." That was funny. Um, so is it? But this sort of makes me wonder: is it better to have more of these decisions made locally because there's sort of more democratic accountability and you're closer to the voters, or is it a more sort of a threat because there's at the local level there's more conflicts of interest, or there's less media scrutiny, or there's just less kind of professionalism among the and um, professional background among some of the people who are making the decisions. There's less infrastructure, there's fewer inspectors general, all that stuff that you get with government bureaucracies, which sometimes is good because someone's looking at the bottom line.
Hmm.
Um, where do you think where is that how does that tension work for you?
I think everything you said there is correct. You see plenty of problems at the local level. And I think it just goes to show that, everywhere you go, there are humans, in the federal government, in your local government, and um, where they have a power, it'll be exercised. Um, Local governments are eminent domain abusers often. Um, there's a case, gosh, I think we launched it earlier this year in Brentwood, Missouri, where it's an eminent domain issue, where the local government has just decided that they want to replace a new, I'm sorry, existing commercial buildings with different commercial buildings. And so their tools are limited, and so they decided to designate these commercial buildings as blighted. And when you see so blight under eminent domain law, it's a reason, like it's another thing that the Supreme Court of the United States has sanctioned, which is the Fifth Amendment takings clause doesn't prevent a taking if that property is blighted. It's like in some kind of disrepair, there's some kind of defect. I mean, you would think like shutters falling off, foundations crumbling, rat infested, empty, abandoned, right? Like this is the kind of thing that you would think of if you think of something's blighted, and it's like such to the point where somebody's got to intervene. This is not what's happening. You should see these. I'll give you a link to the case, and you can include it if you want. But you should see these buildings. They are in good shape. But this is a fairly, I'm not sure what the population of Brentwood is, but it's not a big city, right? And it's the local government. They want to have a certain thing happen, and so they reach for the tools that they've got, and there they've got these blight, designation options. And so in order to transform the space in the way that these small group of people think that they want to transform it, they're going to, do what they can. And in this case is just to call these perfectly fine structures blighted. And the result of that would be that all of these businesses who have spaces that they've developed out and at great cost to themselves, it would probably put them out of business to force them to move, right? And so IJ is helping them resist this just completely illegitimate, taking. So like you can see how another small government. Gosh, I'm blanking on the location, but they just didn't want a certain hardware store to open up in a certain locale. So they're just going to bulldoze it and turn it into a park that they're calling it a passive park. Like nobody's going to use it. They're not going to put any trails in or playgrounds or anything like that. They're just saying that, they're going to blight this building no, they're not going to blight it. They just want a park, but they don't want a park that anybody will use. And so that's pretext, right? Like that's pretextual.
Right. So in other places, a passive park would just be called an empty lot.
An empty lot. Yeah, that's right. Yeah, they're gonna let the native plants take over. See.
Well, in the case of those, the buildings where the town of Missouri is trying to designate them as blighted, but there are actual existing small businesses operating out of them. Right?
Yeah.
Like you said, you would imagine they would be empty and falling apart. Not only are they not empty, there's actual businesses operating.
Oh yeah, one's a kitchen. There are people coming to do kitchen classes. They've got all these refrigerators built out. One's a shop that's like like some kind. They use it's like fishing equipment that they manufacture there, and it's like built out the way they need it. Another's a dance studio that people have really customized their spaces, and they're lovely. And so I'm just saying that, of course, we all think of the federal government as this heavy hand, and it is, and it's difficult to resist. Localities engage in this kind of activity commonly, and there's the whole blight designation thing. The town of Ocean Springs, Mississippi, they have a redevelopment plan. They've got, some tourist action happening in Biloxi. The local property values are probably rising, and they see a better use than this traditionally, historically Black neighborhood. And they've designated their neighborhood blighted and didn't even let them know. They had no idea. They gave them 10 days to challenge the blight designation. And of course, nobody knows about it. And you should see these homes. They're not blighted. So anyway, these are local municipalities doing what they can to, I should say, it's not just local municipalities, right? These are small groups of people that have the power of government who are, reaching for the tools they've got, and they will reach for them.
Well, yeah. So when it comes to some things like the states might do, for example, like the states that passed the property rights protections after the Kelo Supreme Court decision, you could have a situation where a state could step in and say, cities don't get to do this anymore. If someone wants a designation that is going to justify an eminent domain property seizure, you have to come to at least the state level. Like every little city doesn't get to do this on their own. You could have a state that decided to sort of preempt local localities that way if
Right.
they wanted to guard against that.
Right. Yes. That's how that works. So, federal law can preempt state law, if it's by being more protective. State law can preempt municipalities.
But yeah, so if there were so many states in the late 2000s that were willing to pass those laws in reaction to the Kelo decision, maybe there's a sort of second round to be
Yeah.
done where you could say
Right.
states actually, these guys at this like town of 5,000 people, they're kind of getting out of control here. Maybe you should pull those powers back a little. Um, well, this is great. I think you already told us what the current state of the case was. It is the board down in Georgia, and you're waiting for a decision from
That's
that
right.
board, and then
Right.
presumably that decision could be appealed, and then so if it does, so if it doesn't go IJ's way and the property owner's way, what would be the next step after that?
The next step would be appeal to the courts. So right now it's at the Public Service Commission. That final decision will be in spring of 2024, and then presumably somebody's going to appeal, and then it'll go to the lowest trial court, will act kind of as an appeal court, and then it'll appeal to Court of Appeals in Georgia Supreme Court, and potentially the United States Supreme Court as far as the appeal route goes. So
All
it'll
right.
be a little haul. I
Well,
do. Oh, go ahead.
yeah, we'll wait to see how that turns out. What anything else you want to leave us with?
Yeah, I just do you want to hear just like a couple of fun moments from the hearing that are
Yeah,
just kind of like, the things that come up, and the president of the railroad here uh, he was being cross-examined, and by the senior attorney on this case. His name is Bill Maurer from IJ, and Bill was talking about this talking through the nature of his taking, and of course the railroad president at one point, I think it occurred to me that he got a little bit offended that we'd been saying that these properties, that he was trying to take these properties, and he said that nobody's property is being taken, right? This is everybody's going to be compensated for their property, and Bill said, "What do you think is happening here?" And he said, "I think we're in the middle of, this is a condemnation proceeding." And so Bill said, "Well, would it surprise you that the Fifth Amendment to the United States Constitution calls these kinds of condemnations takings?" And he said, "No, I didn't know that." And I think it was, for me, it was just emblematic of kind of the thinking around this area. The condemner, he has to confront the fact that this is a forced transfer that he's engaging in, and that these are properties that the owners want to retain, and it is indeed a taking of somebody's property when you force them to sell it, and of course compensation is not going to be near how they value it, certainly not here. I will share that our one of the families that owns several of the parcels that are in the way of the railroad, they're this community is majority Black community. This family is an African American family who our client's great grandmother was born into, these are all former cotton plantations. She was born into slavery on the plantation where this land currently sits, and about 100 years ago, their grandfather obtained about like 600 acres through work, and their family values it as a heritage to them, and it's extremely meaningful. Several of the family members own these adjacent parcels of, and I can't express to you, like, they testified at the hearing about what all it means to them, and how devastating it is that that it would be like degraded forever by this incursion, and knowing that it is not going to a use that is meant for the public. And these are the kinds of takings that people have. It is incredibly disruptive to people's lives to have their land and their properties, their businesses, their houses taken. And so IJ is here to resist the easy taking of people's property that this kind of movement would, propose to do. And anyway, that's
that's an amazing story about the the family that bought back the property on which their own ancestors had been enslaved and now own that themselves.
it's an incredible thing. One of the things that the president of the railroad said was that, he posed that the railroad is a small business, and this is their American dream to be entrepreneurs in this way and to provide services to people, and it just completely looks over the fact that this is, the Smith family, who I just told you about, this is their American dream, right? To be able to retain property is the American dream at its core. And we're all about free enterprise, but this isn't it.
Right. And I'm sure the president of the railroad would realize that if you told him that you were condemning his house, and he would get paid for it, but he would have to leave in 30 days because we're going to tear it down.
It would never fly. It would never fly. And of course, you're not going to say that at a hearing, but that is the implication, right? That's exactly right, Richard. Never.
All right, Betsy, this has been fantastic. This is a great overview of the general principles as well as this particular important case. And like I said, we'll keep up to date. We will put the links to the studies and resources you mentioned in our show notes at cei.org/blog. And before we go, just tell people where they can find news, stuff about IJ, where you are online, on the social medias.
Well, I'll say that ij.org is a great place to go to learn about IJ. They also are on Twitter and YouTube. And for especially non-lawyers who are interested in private property rights, IJ produces a deep dive kind of podcast, like a legal history podcast for non-lawyers. And the new season of that podcast, which is called Bound by Oath, focuses on private property rights. And so if this is of interest to any of your listeners, that's a great place to go and learn about, the great history in the United States of, property rights and where it's fallen and where we're trying to strengthen it. That's a good reason as well.
Excellent. Thanks so much, Betsy.
Thanks, Richard.